Everyone. Welcome to the Disability and COVID-19 Lessons from Disability, Lessons from the Pandemic panel, hosted by the section on disability law. My name is Doron Dorfman. I'm an associate professor of law at Syracuse University College of Law. Before we start, I would just like to thank Professor Katie Ayar for her work and leadership of the AALS section on disability law this year, and for organizing such an incredible program today. I would also like to thank our sign language interpreters for being here with us today, Don and Anthony. And I would like to give us some background about the panel and then go right ahead to our wonderful panelists for today. So the COVID-19 pandemic has had a grave impact on the lives of all of us. But what became clear as time went on is how the pandemic reflected and exacerbated existing inequalities and the marginalization of already underserved communities like people of color, immigrants, etc. So many disability law-related issues and questions surfaced during the pandemic, from questions about rationing of scarce medical devices, to mass COVID infections in institutions, to questions about accommodations for students with disabilities or for employees, and questions about mass exemptions as accommodations, and many, many more. And today in this panel, our experienced and brilliant panelists will explore some of those questions with us. Each of them will talk for about 10 minutes, and then we'll open it up for discussion and for Q&A. Please use the chat room and the chat box to write your questions. I will monitor it throughout the talk, and then we'll moderate the Q&A. Let me introduce our panelists in order of presentation. They will just go one after the other. So first off, we have Professor Jasmine Harris. She's a professor of law and Martin Luther King Jr. Hall Research Scholar at the University of California, Davis School of Law. Professor Harris is an expert in disability law, anti-discrimination law, and evidence. Today, she will talk about the frailty of disability rights to set up the stage for all of our discussion. After Professor Harris, we will hear from Professor Sam Begenstas, who is the Franklin G. Millard Professor of Law at Michigan Law School. He specializes in constitutional and civil rights litigation. He wrote extensively on numerous issues in disability law and policy. And the new edition of his casebook, Disability Rights Law, has just been out a few months ago. He will talk about rationing of healthcare for people with disabilities. Then we will hear from Professor Arlene Cantor, who is my colleague at the Syracuse University College of Law, where she is the founder and director of the Syracuse University College of Law Disability Law and Policy Program, and where she also directs the international programs. Professor Cantor is an expert on international disability law and the UN Convention on the Rights of People with Disabilities. Her talk today is based on her forthcoming article, which is titled "The Future is Here: The Right to Work Remotely Under the ADA." And last but not least, we will hear from Professor Kat McFarlane, who is our new chair-elect of the AALS section on disability law, and we're really excited about having her. Professor McFarlane is an associate professor of law at the University of Idaho College of Law, where she teaches and writes on civil rights and civil procedure. She will talk about how medical documentation requirement imposed on employees seeking reasonable accommodations are particularly problematic during the pandemic. And I would ask Jasmine, Professor Harris, to take it away.
Thank you so much, Doron, and thank you to my fellow panelists and to the section on disability law for putting together such a fantastic and important panel for today. I have the honor of going first, which means that my contribution or my greatest added value is going to be to provide a framework for us and for our discussion here. When the pandemic first hit the media, my first thought as a disability and equality law scholar was, we know who's going to be disproportionately affected. And sure enough, hate to be wrong, despite what my husband may say, I hate to be wrong, but here, this is exactly what happened in this context. And so I rushed to the computer and started writing pretty quickly, as I know, Sam, you did the same thing, to kind of, not as a fortune teller, but almost trying to frame what we would be seeing. And I want to share with you a little bit about that framing today. And most of this comes from a piece that I put out in late April, early May, called The Frailty of Disability Rights or Disability Law, and it's in the Penn Law Review online. And so what the piece really tries to do is to say, at the end of the day, we need to see these problems as expected, as something that is an issue of structural reform that we have not yet addressed. And so what I did in the Frailty of Disability Rights is say, look, here are the things we ought to be looking out for and what we see happening. We started to see how students with disabilities were going to be affected by the pandemic. We knew that this would happen in the sense of the disproportionate impact. But why is it so important for students with disabilities? Well, we think about the regression that students with disabilities in particular, all students, but in particular students with disabilities, experience and are going through right now in the household. And the need for support services as well. Imagine a situation where you have a student with an emotional or behavioral disability who needs to get the social emotional support in his or her IEP and cannot get that. That is the crux of the IEP. That is the crux of the support services that are going to allow that individual, that student, to access a free, appropriate public education. Well, what we saw happening in the state of New Jersey was New Jersey said, hey, parents of students with disabilities, we're going into an unprecedented time. We're going to send you some services, but please sign away your rights. Of course, I didn't say it that directly, but please sign a waiver in terms of the lawsuits you can bring against us in the future. That's not the case anymore. Fortunately, that's been stopped, but that was the first response. And I think that's telling. The first response is people with disabilities are going to be last in line. That is to say, the fact that they have a disability is being framed as a justification, what I've called in the past a disability alibi, a justification for structural neglect and structural discrimination. And so we've seen that in education. Sam is going to talk about his work in terms of medical rationing. We've seen it across the board. We've seen it in legal education. We've seen it in jobs. And so the idea is, we still feel very much so in terms of our social norm that people with disabilities are allowed to be part of the civil rights agenda as the right thing to do. That is to say, it is when all other things are in balance, yes, we can extend these rights. But because there are some conditions, that is to say, some underlying impairment, you are more expendable. We are going to value, or rather devalue, the quality of your life. And I'm not going to talk more about that. I'm going to leave that to Sam and his presentation. But I think the framing is particularly important, and we need to remember this. That is to say, the idea of charity as underscoring disability rights law prevails. So that's what that piece was about. I want to take a moment, though, not just to focus on the bleak part of where we are, but to talk about how this moment also offers opportunity. And so a paper that I'm working on right now is a paper called The Rise of a New Deinstitutionalization Movement. And so the piece really focuses on the ways in which disability law and disability principles, even more so than the law, can become quite useful and thinking about other social justice reform or other areas of social justice reform. And so the idea is, think about the conditions of congregate care, what I call custodial facilities. What unifies the ICE detention centers, the nursing homes, the psychiatric hospitals, the prisons and jails is all the same. It is this structural neglect, this concept of warehousing, and this devaluation of life. And so one of the ways we can use disability concepts would be in the decarceration context, when we're thinking about, and lawsuits are being brought, and I have the good fortune of speaking with lawyers on the ground who are doing this work on how to conceptualize of the rights that are at issue here. Are they using, for example, in the jail and prison, are we talking about Eighth Amendment? Are we talking about procedural due process? Well, we can also talk about disability. We can talk about failure to accommodate, because this is a moment of intersectionality, an opportunity to talk about intersectionality, which folks did this morning, and I know that. I'm not going to go into that. But I will say that look at who's in these spaces, who populates these custodial spaces. People of color, people who are indigenous, who do not have the resources or platform to really fight their position. And so how do we use disability concepts like least restrictive environment that comes out of the Olmstead case? How do we use that in terms of people who are in prisons and jails? Could we not warehouse people in jails? And instead, what's the least restrictive environment for those individuals? So I'm not going to unpack this completely, but I will say that I think this is both a moment of reflection, not only because we are 30 years out from the Americans with Disabilities Act, and it is a time to think about the future, but also to think about how disability principles, maybe not the exact laws themselves, although they can be useful, such as Title II in the context of prisons and public institutions, but the concepts, least restrictive environment, integration, the concept of habilitation, Youngberg versus Romeo, these kind of principles that we've seen in disability rights that are so important. How can we export them into other areas of law that have real connections in terms of the affected populations and overlap? So I'm going to stop there, and I'm going to pass the baton to Sam.
Wonderful. Well, thank you very much for that, Jasmine, and thank you, Duran, for the introduction. This is just really an incredible treat for me. I remember when the AALS didn't even have a disability law section, and now the disability law section has become such a terrific institution of this organization, and we get so many people seeing how important it is to think about legal issues and policy issues through a disability lens. And so just the opportunity to talk with this group, with so many people who I really look up to, someone like Arlene, who was doing this well before I was in the Academy, and some of the really terrific people who've come into the Academy since I got here, like Duran and Jasmine and Kat. And so this is just great. I'm really thrilled about this, and I'm mostly just saying a bunch of stuff because it's really hard to follow Jasmine, who really set the table very nicely for this, and I think did a great job of showing how disability issues are sort of running through all of the responses to the pandemic, all of the effects of the pandemic, all of the questions we're confronting with regard to the pandemic. And that's what you're seeing today. I'm going to focus for the rest of my few minutes on just one slice of this, which, like Jasmine, is something that I wrote about basically 9 months ago when the pandemic began, although it's something I continue to write about and evolve in my thinking about. And that is questions about rationing of treatment for COVID on disability grounds. And the origin of this project is a real world origin, right? So when we had the first big wave of COVID last spring, and it looked like hospitals around the country were going to be overwhelmed. Certainly hospitals were being overwhelmed in a couple of key parts of the country. And at the time, there were not very well-evolved treatments. And so one of the crucial ways people thought we could save the lives of people who had very severe involvement of COVID was providing ventilators. And there just weren't enough ventilators to go around for all of the people who needed them. And what we discovered very quickly that states and hospital systems had, in response to a bunch of professional advice, created these so-called crisis standards of care, right? The usual standard of care in the American medical system is if you're sick, you get the treatment that you need. But when the system is overwhelmed and there aren't enough treatments to go around, the basic view within the professional community is we need these special crisis standards. What do we do when there's not enough to go around, right? When we flip the switch to say the system's overwhelmed. And when people started to dig into what the crisis standards said, it turned out, no problem having crisis standards. That's an essential idea, a good management tool to prepare for something like what we faced. But when we looked at the content of those crisis standards, what we found was that in many states, those crisis standards either explicitly discriminated against people with various kinds of disabilities by saying that they would be deprioritized. If there are two people who are seeking one ventilator, we would deprioritize the person who has a particular named disability, or would be disqualified for these life-saving treatments in circumstances where the crisis standards existed. And these disabilities were often disabilities that had nothing to do with the ability of a patient to recover from the immediate illness. So, for example, one of the most notorious ones was in Alabama, which identified intellectual disability as a basis for refusing to provide a life-saving treatment to someone in a circumstance of scarcity, but many, many other kinds of either explicit exclusions or deprioritizations of people with disabilities, or uses of various formulas that took account of disability in particular ways that made it difficult for someone with a disability to get to the head of the line for a life-saving treatment. So that led me to do a bunch of work on a couple of tracks. One was a track of advocacy, working with advocates from around the country, both national advocates and advocates on the ground in particular states, to file complaints with the Office for Civil Rights at the Department of Health and Human Services to say these rules violated the ADA, and also led me to do some writing about some scholarly writing about why I thought the best way to think about this was as an ADA violation and what the problem is. And so let me just spend the next few minutes talking about what I think the problem is. We can happy in Q&A to talk through various legal questions, but what's essentially wrong with saying we're going to deprioritize people with disabilities for life-saving treatment? Well, you have to look at why people with disabilities are being deprioritized for life-saving treatments. And the reasons ultimately work out to a couple of things. Predictions about the length that someone will live after they recover, right? So again, most of these are not you have a disability that makes you unable to recover from COVID or unable to have any therapeutics that exist actually work to eliminate the COVID in your system, but instead predictions about how long someone will live after they recover, or predictions about the quality of the life they will live after they recover. And the idea is that the idea behind these deprioritizations and exclusions is that in circumstances of scarcity, what we want to do is we want to save the most years of life, or we want to save the most quality adjusted life years, or something like that. And so a few problems there. I mean, one is you can just sort of say, look, this utilitarianism that is behind this doesn't work for me. I'm going to bracket that. Another problem is that the predictions of both quality and quantity of life are likely to be biased. The predictions as to quality of life, this is something, Liz Emmons has written a lot about, tend to be, what is the quality of life with the disability? It turns out that in general, if you ask disabled people what the quality of their lives is with a disability, you're going to get a different and much more favorable answer than if you ask non-disabled people what the quality of life with a disability is. And these the characterizations of life with a disability as being low quality tend to be based on this outside non-disabled view. Now, deep normative questions about which views we should accept here, but I would just say we shouldn't lightly accept the view of people without disabilities that, oh, it must really suck to have a disability, particularly when the consequence is to say, therefore, we're going to put you out of your misery by not giving you life-saving treatment. What about predictions of life expectancy, quantity of life? Well, here again, we have very consistent evidence in a variety of fields and in a variety of ways it's been developed that disabled people tend to be under, when disabled people go to doctors and medical professionals tend to think that they're likely to live for a shorter period of time than they in fact are going to, particularly when they come with some separate condition that is not related to their disability. Their prognosis tends to be biased in the negative direction. So again, we have reasons to believe that bias is at play and that this is not reflecting truth, whatever that may be, about how long someone's likely to live with a disability. To the extent, however, that people with disabilities live shorter lives or live lives that are experienced by those individuals as of lower quality than non-disabled people, a substantial part of both of those things has to do with discrimination. Societal discrimination, medical discrimination. It's discrimination and denial of access to opportunity that's a crucial aspect of the negative feelings that disabled people report about their lives when they report those feelings. It's discrimination by the medical system that means that disabled people don't get good treatment for underlying conditions. And, you know, again, extensive literature about this. Often medical professionals will attribute negative symptoms to the disability and assume that that's fixed, as opposed to actually looking deeper and finding out, well, no, this person has a separate treatable condition. So, and, you know, various other pathways like that. So to say that because you live a life that experiences unpleasantness due to societal discrimination, or you live a life that's likely to be shorter due to societal discrimination, we're going to discriminate against you in providing life-saving care, is to load injustice on top of injustice. Now, the major push against this is this view that I've articulated, is a view that we need to save the most lives possible. Look, it's a pandemic. You know, it's an emergency situation. What are you saying? We should save fewer lives so that we should save disabled lives? Well, you know, if in fact the predictions about how long people are going to live with disabilities are wrong, actually that trade-off is not as much of a trade-off as you think. But I want to say one thing, and then I'm going to be done, about the trade-off. Assuming there is a trade-off. So assuming what you're going to do if you don't deprioritize disabled people is you're going to mean that we save fewer lives at the moment of the emergency. I think what you ought to be doing is thinking about this in a larger time frame. You ought to be thinking about this as a dynamic situation. Sure, the clinician at the bedside of the particular person who has COVID and is about to die is going to be making a particular decision. We're talking, and is going to try to save that life. We're talking about policy decisions that are made in advance of a pandemic. And there are a couple of crucial policy decisions here, right? One policy decision is the set of criteria you're going to use to allocate scarce ventilators or scarce medicines. But that scarcity is not a natural fact of life. That scarcity is itself the result of policy decisions that were made well in advance of a particular emergency. And so what I urge in the paper I wrote and also in general is that we think about this as as a question of how society should respond to the predictable emergencies where we're going to have too many people chasing. And so we should be thinking about these decisions as decisions about how we set up the system from the beginning, so we don't set up the system with predictable scarcity in a way that disabled people are almost certainly excluded from the decision-making process. And then at the back end, we don't put the burden of the scarcity that we have created on the disabled people who are excluded from the beginning. And that's essentially the argument. And I'm really happy to pass on the baton now. So thank you very much.
Hello. Thank you, Sam. Thank you, Jasmine. Hi, everyone. Thank you, Jerome, for convening this panel. This has been quite a day, I think. I just want to echo appreciation for the disability law section and all the work that's gone into presenting these panels. My work is going to be taking us in a bit of a different direction. I want to talk a bit about an article I just finished called "The Future is Here, the Right to Work Remotely Under the ADA." And as we know and we've discussed, COVID-19 pandemic is a tragedy of epic proportions. And let's call out the fact that, in fact, people with disabilities, as Sam and Jasmine discussed, are perhaps more at risk than other parts of the population. 3 times more people with disabilities have died of COVID than people without disabilities. Disabled children have been largely abandoned by their school districts. And the social isolation caused by the pandemic has resulted in an increase in suicides and demand for mental health services unlike we've ever seen. But amidst this tragedy, the advances in technology have facilitated opportunities for more people than ever before to talk, meet, and work remotely. Prior to the pandemic, at most, maybe 1 in 4 employees worked remotely, depending on the industry. Today, more than half of the nation's labor force is working remotely, and some estimates predict about 71% right now are working at home, either part or full-time. By all estimates as well, remote work is here to stay. So these changes in the national labor force present an opportunity, I argue, for disabled people. Although not all jobs can be done remotely, and for sure, not all employees with or without disabilities would choose to work remotely. Remote work does have the potential to facilitate the development of greater employment opportunities for some people with disabilities. And increasing employment opportunities is so sorely needed, since now 30 years after the ADA, as of December 2020, only about 29.4% of disabled people are employed, compared to about 66.3% of people without disabilities. So remote work, as I see, is an option for employees and potential employees who have difficulty finding or keeping jobs because of inaccessible workplaces or lack of accommodations, difficulties arranging transportation to and from work, or meeting other challenges at the work site. As such, remote work furthers the primary goal of the ADA to assure equality of opportunity for participation, independent living, and economic self-sufficiency. The increased availability of remote work also has the potential to eliminate certain workplace barriers, including ableist attitudes and disability prejudice that continues to permeate many workplaces today. Of course, the way to combat ableism and prejudice and discrimination is not to encourage the absence of disabled people at the worksite. Our sordid history of placing people with disabilities out of sight and out of mind must never be repeated. But authorizing remote work as an option for those employees with disabilities who request it would provide, in my view, disabled employees greater autonomy and control over their work lives, as I discuss in greater length in my article. So in this brief talk, I want to focus now really on my review of the case law and the right of people with disabilities to work remotely under the ADA, and to present an argument for the need for changes in the EEOC regulations from a critical disability legal studies perspective. Over the past decade, as far as I can tell, every circuit, except the 4th, has decided 1 or more remote work cases under the ADA. Of those cases, most rule against employees seeking to work remotely. Courts typically just defer to the employer's judgment regarding whether working on site is an essential function of a particular job and whether allowing an employee to work remotely would constitute an undue hardship on the operation of the employee's business. Upon my review of all of those cases for all of the circuits over the past decade, what I found is not only conflicts among and within circuits, but a clear lack of clarity regarding how these cases are decided, as well as the disability, prejudice, and ableism that is embedded within many of the decisions by the employers and the courts. Based on this review, I suggest it's time for the EEOC to amend the regulations and make it clear that remote work is an appropriate and even preferred accommodation for some employees with disabilities in some jobs. Look, of course, cases involving an employee's request to work remotely require a careful balancing of the needs of an employer and the rights of an employee. But that's not what I saw. What I found in this review of the cases is most striking is about the developing law in this area is how little evidence has been presented or required by the courts to show the employer's, quote, undue hardship. Indeed, most cases focus on the employer's negative view of the employee's attendance or performance record of the workplace, rather than any alleged hardship posed by remote work. One court has held that prior job performance or the employer's attendance record of the workplace has no bearing on the reasonableness of a request to work from home. But most courts use poor performance, as a basis to deny a remote work request. On the other hand, the courts that have ruled in favor of employees seem more persuaded by equity issues and the fact that an employer had permitted other employees to work from home, or that the requested remote work arrangement would be temporary and time limited as opposed to indefinite. The issue for the courts in remote work cases, it seems to be, should not be whether or not the employee has a perfect employment record prior to request to work, but remotely, but whether the employee can perform the essential functions of that particular job remotely. Except for some cases decided by the 2nd, 6th, 9th, and DC circuits that have held for plaintiffs seeking to work remotely, most circuit courts simply defer to the employer's judgment, notwithstanding that the Title I regulations include employers' judgment about essential functions as only one of 7 factors to be considered. One reason I think that courts may feel free to defer to employees' decisions is that nowhere in the EEOC regs or the guidances is it prohibited to consider employees' prior work history or attendance record at the workplace as a justification for denial of requests to work remotely. Nor do the EEOC regs require any consideration of the employee's judgment regarding why remote work should be feasible. To deny an employee the right to work remotely as an accommodation without providing the employee any chance to show whether or not they can perform the essential functions of the job remotely is an example, I argue, of an adverse employment action against a person with a disability that Title I was designed to prevent. In my proposed article, I suggest 5 ways in which the EEOC regulations should be amended, and I'll just go through them quickly here. First, the EEOC, I think, should amend the current regulations to specifically list remote work as a reasonable accommodation that can be denied only if the employer can show an undue hardship by clear and convincing evidence, and that the essential functions of the particular job cannot be performed remotely. The employer's prior work history or attendance record would not be considered as part of that decision. Second, the employee's judgment. Courts often defer to the employer's judgment about whether or not physical presence in the workplace is an essential function. Not surprisingly, employees often are the ones who make workplace rules. But with respect to a request for remote work, the employee's judgment, including information about the benefits, difficulties, or particulars of how the employee would perform the job remotely, is particularly relevant and should be considered. Number 3, I argue that the EEOC should draw on the fundamental alteration defense under Titles 2 and 3 of the ADA. If the nature of the work performed remotely would change so fundamentally the specific job at issue, then the request to work remotely should be denied. On the other hand, if there would be no fundamental alteration in the nature of the work or the specific tasks involved in performing them remotely, the employee's remote work request should be granted. 4, the EEOC should clarify that any workplace policy requiring physical presence as an essential function may violate the Title I of the ADA as an unlawful qualification standard or selection criterion that, quote, screens out or tends to screen out an individual with a disability or a class of individuals with disabilities on the basis of disability as prohibited under the ADA. To avoid such discriminatory action, an employee would have to show with clear and convincing evidence that a particular employee cannot perform the essential functions, and that requiring physical presence in the workplace for that employee is job-related and consistent with business necessity. That is not what I have seen that's been shown in the cases I've reviewed. 5, employees now may claim that by granting one employee's request to work remotely, they'd be required to grant all such similar requests, and that could present an undue hardship in the aggregate. But the EEOC regulations require an interactive process between the employee and the employer in particular, one-on-one, to determine the reasonableness of that employee's specific request for accommodations. The EEOC therefore should amend the regs to remind employers that they are not permitted to deny an employee's request for a reasonable accommodation, including a request to work, because of concerns about the potential or hypothetical costs of similar accommodation requests by other employees or even the entire workforce. So in conclusion, when the ADA was written in 1990, there were no smartphones or even high-speed internet connections. Even in 2008, when the ADA was amended, technology had not advanced to the point today where it is now as possible to communicate with one person across town as it is to Zoom with hundreds of people around the world. These advances in technology, coupled with the risks of the pandemic, have resulted in an exponential increase in remote work. And even after the immediate threat of COVID subsides, many of those who suffer from the long-term health effects of the virus will become newly qualified under the ADA as disabled. Moreover, as our population ages, more of us will qualify as disabled. It's already estimated, I learned, that more than 1 in 4 of today's 20-year-olds will experience a disability before they retire. Accordingly, there's no question that the number of employees who may need workplace accommodations will continue to increase in the years ahead. And although not all jobs, again, can be done remotely, and remote work is not for everyone, remote work does offer many advantages, and people with disabilities should be able to take advantage of them. In fact, as more employees began to work remotely during and after the pandemic, people with and without disabilities were placed on equal footing for the first time. During the pandemic, people without disabilities were unable to get to work, access stores, supermarket, restaurants, and other places where they could get the goods and services they needed. Just like disabled people, many of them have been experiencing a lifetime. Another unintended consequence of remote work has been that people with disabilities are now seen as resources to support their non-disabled remote co-workers and their employers. As one disabled activist recently wrote, "We know how to stay in touch remotely, be socially connected while physically distanced, make limited resources in tight situations, make plans and adjust on the spot, and work through challenging circumstances." In order to further the mandate of the ADA, I argue, the EEOC would be wise to acknowledge our current economic and public health realities and revise Title I regs to provide greater clarity to employees, their employers, as well as the courts, that remote work is a reasonable and even necessary accommodation in many more workplaces, for many more types of jobs, and for many more workers than were thought eligible prior to the pandemic. Thank you.
Thank you so much, Arlene. It's an honor to follow you and to be on a panel with Sam and Jasmine and Daron as well. Thank you for your moderating skills. I cite all of these scholars in my current work, and I know I'll continue to cite them in the future. As Sam mentioned, our section is relatively new. It was formed in 2007 as a result of much of the work undertaken by Arlene, who's here today, and also Laura Rothstein. And if you haven't joined the disability law section already, please do so. It's a section that is collaborative. You will find scholars who are brilliant writers, but do not divorce their work from advocacy. And that carries over into the way they interact with their fellow colleagues as well. Okay, so I'm going to talk today about how reasonable accommodations have become so dependent on medical documentation of disability. I'm focusing on the context of employment, much like Arlene. Your research is going to inform mine. This is part of a larger project I've undertaken in which I compare the way disability must be verified to the way religious accommodation cases and religious accommodation regs take a hands-off approach to an employee's representations that they hold certain religious beliefs. So my paper that I'm working on is called Disability Without Documentation. Today I'm gonna, if my dog permits, I'm gonna briefly explain how the reasonable accommodation process was envisioned and what it has become and how problematic the current regime is during a pandemic. I also have a few thoughts about how to move forward, inspired by steps taken by the EEOC last year. So what process am I examining? I'm looking exactly at a very early step. How does an employee with a disability obtain a reasonable accommodation at work? So imagine someone with rheumatoid arthritis who needs ergonomic office equipment. So she tells her employer, this is what I need. What exactly happens next? Well, typically today, that employee has to fill out a multi-page form that includes a section called Medical Verification and Disability. I'm gonna let the bad dog out behind me. Hold on, guys. That's Cooper, who is the opposite of a service dog, if you can imagine that. Okay, so if you're thinking, if your work involves a difference between the medical model and the social model of disability, what I just said is probably a huge red flag, as it should be. So the ADA itself doesn't include a step-by-step process about exactly what the reasonable accommodation process should look like, but courts have read an interactive process requirement into the statute. The interactive process is what Arlene referenced as well. And so the interactive process can be traced back to a 1989 Senate committee report. It's all over the ADA's legislative history. And the legislative history tells us that that process by which a reasonable accommodation is settled upon should center an employee's experience and knowledge. In fact, the very earliest steps go something like this, according to the legislative history. After receiving a request for an accommodation by an employee, employers are encouraged to solicit suggestions for reasonable accommodations from the employee herself. That sounds great, right? Okay, and so the regs and interpretive guidance pick up on this legislative history, and the EEOC's guidance goes even a step further and says if there's any confusion about what a disability is or what accommodations might work, employers can seek guidance, but from whom? Well, from the EEOC itself, from state or local rehabilitation agencies, or from disability constituent organizations. I love that. That sounds great. It has nothing to do with how accommodations are actually settled upon today. So the practice endorsed by courts essentially allows an employer to require an employee to find a medical provider, typically a doctor, who must prove that an employee is disabled. And that's during the interactive process, right? Step aside from what's required even at summary judgment. Nicole Porter has written about what this looks like in litigation. We're talking about that very first step. And not only must a doctor usually define what the employee's disability is, they also, that medical provider, usually a doctor, gets to say or has to say what accommodations are needed. So there's interesting language in the case law about why exactly this is, and I'll tell you where I think it comes from in EEOC guidance. But let me give you a sense of what courts are saying. There's a 1998 Sixth Circuit case, Prevost Family Market, that's actually a direct threat case. It's a case in which an employee identified himself as someone who is HIV positive, and much of the case has to do with providing medical documentation of when an employee says he is, right? And the court in that case said, well, an employer need not take the employee's word that the employee has an illness that may require special accommodation. That particular language gets quoted in district court orders in the Sixth Circuit by the Sixth Circuit itself, and it's bled into other circuits as well. So my review of the case law also shows that an employee can't, in fact, suggest accommodations themselves. And if doctors write one note and then an employee or an employer says, well, this is kind of vague, I need more, and the doctor won't do it, that lack of information is imputed to the employee and is reason to deny a reasonable accommodation. So how did this happen? We'll set aside all of the regs and guidance and legislative history surrounding the interactive process. And if you look at everything about medical examination and inquiries, then we see a different kind of story play out about exactly what employers can do. So the ADA itself is quite clear that the default rule is that medical examinations and inquiries by employers are not allowed, right? They are disability discrimination, unless they're job related and consistent with a business necessity. That's as far as the regs go. EEOC guidance about that particular aspect of the regulations goes further and says this particular aspect of the regs permits employers to make inquiries or require medical examinations necessary to the reasonable accommodation process. So despite everything, this beautiful system set up by the interactive process part of the legislative history, regs, and guidance, we have a totally separate area of the law that has infected the process and controls the process. It was supposed to be a conversation. It's an incredible departure. Okay, so let's think about how this works during the pandemic. Asthma, for example, is a disability that prior to the pandemic might have required a reasonable accommodation, but likely not one to work from home, right? So to the extent that asthma increased the risk for severe illness from COVID, and we know that it does, right? Workplaces might no longer be safe for people with asthma. So to avoid COVID, someone with asthma may ask for a reasonable accommodation to work from home. Think about the medical documentation regime I just described. How would someone go about getting a reasonable accommodation? Well, they need health insurance. They need a doctor. They need a doctor who probably has prior knowledge of the asthma, a doctor who will let that patient make a non-emergency appointment during a pandemic. And then you need a doctor who will actually write a note or fill out a 6-page form. And Duran's going to put a link to an example of one of these forms in the chat function at the end of my talk. The doctors are not immune from politics, right? In fact, I can tell you from my own experience, I have to fight with doctors about wearing a mask in a medical office. So imagine whether a doctor has feelings about whether people should be working from home during a pandemic, that could influence their decision about justifying an employee's request to work from home. So the EEOC had some awareness of this. They conducted a webinar on March 27th of last year and said, well, the ADA still applies, to which I say, yeah, thanks, appreciate that. But they also said employers can still verify, again, this word verification, that an employee does have a disability and that an accommodation is needed, which goes back to what I just discussed. It really doesn't change the accommodation medical documentation requirements. Okay, what they did say though was that employers should understand that because of the health crisis, many doctors may have difficulty responding quickly, very true, and that there are other ways to verify the existence of a disability. And this is where I think there's a path forward and a way to adopt what the EEOC suggested into the future pandemic or otherwise. So they suggest that a record of a prescription could document the existence of a disability, or a health insurance record. But again, think about what that presumes. Who has health insurance, let alone a health insurance record? And then if the employer is waiting to receive documentation, they can provide the accommodation on a temporary basis, which again should be the rule, right? It shouldn't be this thing that we consider to be outrageous, like a TRO in the accommodation process. No, just give people the accommodation, and if you need more, keep it going in the interim. All right, so I'm going to give you a little bit of anecdotal information to explain how dire this was. When the pandemic hit, I got messages from friends all over the country and all kinds of employment, panicking because I didn't know how to go through the reasonable accommodation process. My own employer went to face-to-face instruction last fall. Keep in mind, I don't need to tell you this, I don't need to emphasize this, but I'm a privileged white woman. I'm the incoming chair of the disability law section, and I almost did not get permission to work from home. My employer said I needed a doctor's note. They have reams of documentation already that I have an autoimmune disorder, that I take immunosuppressant medication, ×3. There's no debate. I'm high risk. I needed a doctor's note, not just saying that I was high risk, but saying that I should work from home. I asked my doctor said our practice is not providing medical notes for COVID-related work from home requests. The practice group that my doctor is a part of happened to be one of the 2 major hospital groups in my city, in the most populous area in Idaho. So that decision affected a huge swath of people, and I thought it was politicized. I'm very lucky and very privileged. I have friends of mine who started tweeting about this, and the hospital group's PR rep got involved. She denied that there was such a policy. Of course there was, and after 3 hours worth of phone calls with one of their administrators who told me they'd write the letter if I stopped tweeting about it, I got my letter. Take away everything I know about reasonable accommodations, my privilege, strip me of all of that. There's no way I would have been able to get a note allowing me, with a 30+ year history of an autoimmune disorder, to work from home during a pandemic. So let me go back to where I started. We don't need medical documentation of disability during the interactive process, certainly not during the pandemic. Go back to that conversation that the legislative history envisioned. At least take steps to go back to it. There's interesting scholarship comparing religious accommodation to disability accommodation in the workplace by Dallin Flake. And he too has reviewed the interactive process and its legislative history. And his conclusion is that in theory, the disability accommodation process is superior. I agree, in theory it is. In practice, unfortunately, it's ableist. So if you want to take a look at what these forms look like, what folks are still having to fill out and get with respect to medical verification of disability, Duran's going to drop a link in the chat. And with that, we can move into our Q&A portion. Thank you so much, everyone.
Okay, so thank you to all the great panelists. I think something we also shown that was also shown during this panel is resilience, and how people with disabilities and disability scholars are very resilient, even if unexpected troubles happen. And we're sorry for this technical function that happened. We have a few questions, and we have a little bit of time for questions. I would like to pose the first questions to all the panelists. So some of you, and it's a question that I had in mind for a very long time, and I think some, like Arlene and Kat, have mentioned that COVID-19 might actually create more disabilities, more people with disabilities. We still don't know the long-term effect of the virus on people who actually were affected by it. And I was wondering, how do you think this would affect disability law in general and perceptions about disability outside the law as well? So this is an open question to everyone before we move on to other questions that were in the chat.
I'll start, I suppose. I'll just emphasize something I mentioned, that I think the way we have been living under COVID has made a lot of people more aware of environmental and attitudinal barriers that exist and to which people with disabilities have been subjected for many years. And so as more and more people have health effects as a result of COVID-19, then I think, and I'm hopeful, perhaps that awareness will increase. And the benefit for the disabled community is that they won't always be as othered. They will be seen as more part of a norm rather than separate and excluded and marginalized. That may be overly optimistic, and I don't want to say that I'm looking forward to that at the expense of more people who have health issues. Let's be clear, right? But it does possibly create more and greater understanding for why disability rights laws will become so important. I'll leave it at that.
If I may jump in just for a moment, I think, and I'll wear the pessimist hat, Arlene, I think part of this is going to depend on how frank our conversations are about disability, and specifically how many people who may have health conditions actually see themselves as people with disabilities. And so it comes down to a question of identity and identification as much as whether or not they meet the legal or the statutory or regulatory definitions of a person with a disability. And so I have a paper that's forthcoming, and it's called Taking Disability Public. And it's a paper that argues that we have this approach to disability identity that is rooted in privacy and privacy laws and other provisions of anti-discrimination law basically reinforce, and not all of them, but there are certain provisions and examples of where we do reinforce that privacy. Yes, you have to come forward, as Kat says, to ask for reasonable accommodation, but there is a complicated notion of disabilities association with a private personal fact that dates back to, as is in feminism, this notion of the home and the public sector being sort of different. So I think we need to have conversations that are also about identity, who we see as people with disabilities, and contend with what Duran writes about in terms of the fear of the disability con. We have to have these really frank conversations.
Yeah, I will add just a little bit. I don't know whether to be optimistic or pessimistic. I think one of the real worries, one of the things that leads me to pessimism, is the way that throughout COVID, we've seen essentially this effort to make disabled people invisible, whether in the context that I was talking about, or in the context that Jasmine began with, school accommodations for kids with disabilities, or just the incredible degree to which the COVID pandemic has hit so hard on people who live in congregate facilities, and the rhetoric around COVID from so many people. Oh, don't worry, it's not a problem if you're young and healthy, right? There's this sort of rhetoric that is very ableist, it's very eugenic, and it's not just rhetoric. I mean, it underlay the policies of the federal government and of many states, and has obviously pretty broad support, even if not majority support, among people. So that makes me really worry a lot. That's the negative. Now, it is true, one of the things about disability has always been that disability, notwithstanding the backlash the ADA has caused, and it was real backlash, disability protections, disability discrimination protections, accommodation requirements, et cetera, have always gotten what seems like surprising support from, conservatives and Republicans for a whole bunch of reasons that several of us on here have written about. But one crucial reason has been everybody's got disability in their family. Everybody, though we don't all know it and we don't all want to admit it, everybody is going to be disabled at some point if they are lucky enough to live long enough and they're not disabled already. And the fact that disability is everywhere does sometimes create opportunities. It also creates anxieties, which feed the backlash, right? It's a complicated story. I think, Duran, when you talk about, the prospect of long COVID in particular, right? I think that does create both the opportunities and some of the risks. And so I don't know which way this is going. I mean, I think, for all the reasons people have been talking about, this is really a transformative moment for America's response to disability. I just don't know which way it's going to go.
It's going to be interesting. We're going to have a greater number of people with chronic illnesses and invisible disabilities, people who may need disability parking placards, who don't, appear on the surface to be disabled. I'm thinking of some of Jasmine's work surrounding aesthetics when I say that. And my concern is that COVID is going to become this moment in time, surrounded by language like, well, we all rallied together and we came together, and that it won't carry over into the future. We seem to, and even the accommodations are well suited to folks who have temporary serious illnesses that they recover from, as opposed to long-term health that doesn't go away. And I think our disability law still does a poor job of helping folks really gain equality to the extent that they have something that will never be resolved. And that's a larger problem with American culture. We love to rally behind people that have very serious but very short-term illness, and even questions surrounding health that aren't met with an answer that you're doing better or that a surgery went well, something along those lines. People have a difficult time listening. And so I think folks with long-term COVID complications are going to experience that kind of discrimination. I don't know if we'll adapt just because there are more of them. I think they'll just simply experience what others already do with chronic and invisible disabilities.
Thank you, everyone. We have about 20 minutes and we have 2 more questions. So the next question from an audience member who I can't see his name or her name, they asked about whether the shortcomings that were a result of the COVID pandemics highlights gaps or shortcomings within the ADA or other disability laws, or whether it's possible to address all those issues we're discussing with existing legislation, meaning whether it's an issue of compliance or whether we need a new framework or a new type of legislation to help us deal with all the shortcomings that we saw with COVID. And just let's be a little short with that because we have another question after that. Whoever want to pick it up.
I think, first of all, that question is my research agenda. So let me see if I can do this very quickly, which is to say that the heart of the question has to do with the relationship between normative shifts and the effectiveness of the law, and whether the tweaks in the actual statute or even additional legislation will help us advance the norms. I don't know. I mean, I think, in my work, I like to think that, yes, there are ways that we can use law to advance positive social norms, anti-discrimination norms about disability. I think we need to get creative. One of the things I'll say this very quickly, in my paper, the Taking Disability Public, one thing that I argue for is, well, if you want a graduated approach to coming out or to disclosure in the workplace, you might adopt something like what Ian Ayres has proposed, which is this kind of identity type of escrow where you bank identity and you try to get an aggregate number of people in a workplace so as to not have to deal with the first actor problem. That is real. That is real in terms of the dangers of disclosing. But that might begin to shift norms. And it's a less radical approach than standing up as Harvey Milk and saying everybody come out as a person with a disability. But anyway, I'm happy to follow up with people who are interested in that.
I'll just chime in to add on. I think the answer is both. There are short-term and long-term goals. There are pragmatic solutions. I mean, I'm proposing change the regulations. How modest can I be? If I put on my international human rights hat, I think that the CRPD, for example, the Convention on the Rights of People with Disabilities, has a great deal to teach us here in America about how to achieve equality. We're stuck in an anti-discrimination model that requires someone with a disability to show they're not like everyone else. I don't have to go on. There are serious problems within that model. And I think COVID has highlighted the serious models of anti-discrimination laws, as Jasmine and Kat and Sam have identified here. So I think we all have a lot of work to do, and on any front, and all fronts.
I'm just going to say something myself really quick before we move on to the next question. I think disability law has a compliance issue, but it also has an attitudes issue. And as Kat mentioned, anything from disabled parking spots to learning accommodations in college to Social Security benefits. to lines at Disney, as I write about in my papers, are all, regulatory solutions that do not work, that people are really, really afraid of being conceived as cheaters, as fakers, as people who commit disability con. And I think, first of all, I think some of the issues of compliance are not specifically can be addressed with a new law or a new legislation. It's somewhat related to people's attitudes and people's perceptions. And I think that's why a lot of the work I do empirically and Jasmine does theoretically, and I and other people do theoretically as well, about the this push and pull between attitudes and the legal regimes are actually what we need to really address in the future. Last question is for Arlene or anyone else, because it's or maybe Kat can answer as well, because it's employment related. So post-pandemic, do you think that teaching in person should be considered an essential function of the job for teachers from kindergarten to 12th grade, or for university professors in law schools or outside of law schools?
I mean, it's interesting. Go ahead, Arlene.
No.
So I think it's interesting. K through 12, I guess I don't want to speak out of turn. At the college and university level, we should think about what students want and what students need. And right now during the pandemic, students, I think, contrary to some assumptions, want to be safe and want at least the option of being virtual. And to the extent that we don't answer it in some abstract way, then you can have, I want to box in the answer, but I don't know if it's just a function of whether the employee, teacher, professor has to be there. I think we're just going to have to rethink education and be more honest about perhaps we're not losing that much every time that we're connecting online.
And I agree. I'll just say, to me, yes or no. Let's see. The question was, is teaching in person an essential function? I think the answer is no. I'll just share with you that every year for the past 25 years that I've taught disability law, one of my kind of included questions in my exams or papers has been, is in person, do I have to be here to perform an essential function as your professor? And I'll just say this year when I'm teaching the course, that will be a different analysis. I don't think it is any longer an essential function for many different types of jobs, but as I play out in my article, and as we'll think about theoretically, how do we propose the principles and theories that should be applied to come out to that conclusion? And I think it is different for pre-university level for other reasons.
Yeah, I think we have one more minute. So if anyone wants to chime in, I'm just going to say one last thing, and I want to echo one panelist in this panel and one person who's not in this panel, but I think her work really, really affects our discussion, and that's Elizabeth Emmons and her great work on attitudes and disabilities, and Sam's wonderful work about the future of disability law. And the future of disability law, kind of like what Arlene said, might not be with an anti-discrimination framework. It might need to be something else, something that imitates other welfare reforms and other ideas from the CRPD or other countries in the world. And I think that's the main challenge in disability law today, which I think really came out in all of the presentation, the terrific presentations that we heard from today. I invite everyone to join us at the section for disability law. I think disability law is a fascinating topic I've been working on for decades, and everybody here we're working on for decades. And I really am happy and delighted to see so many people interested in our work. Please check out all of our works at SSRN or at our other pages. And stay safe, everyone. And I hope that we all, see better days to come and see each other in person really, really soon. Thank you to all the great panelists in the panel.